All right, so you're here requesting a bond?
Yes, Your Honor.
Oh, just 1 second. So let me call the case number. I'm just trying to figure out where we are. All right, the court is calling 2025 CR 0000524, 0000525, and 0002586, State versus Charles Lewis Mullinax. Could I have parties announced?
Jason Garahan for the state, Your Honor.
Victoria Cruz on behalf of Raymond Martinez for the defense.
And are you Mr. Mullinax?
Yes, ma'am.
Do you have any objection to this attorney standing in for Mr. Martinez?
No, ma'am.
All right. State, have you reviewed the motions?
I've reviewed one motion for one case, Your Honor. That's on the 524.
Your Honor, I believed only the 524 was remanded. I thought the others had a bond amount.
Oh, okay. So we're only going on the
524, I believe.
524?
I think so, yes.
Okay.
I'll check with that.
So do you all have an agreement to a bond amount?
State recommends 4,000, which is double. That's fine with us. The original was 2,000.
All right. So why doesn't he have a bond in this case?
He FTA'd, Your Honor. He did explain to me that the reason he FTA'd was because he was injured. He had some broken ribs, and he believed that he would be taken into custody. So that's why I do believe that the period of absconding was only a couple of weeks, and he has been in custody since March 18th.
Wait, let me pull up his case on Odyssey.
Only this one has a warrant. That is remanded, right? I think all the other ones have. No. I asked my staff.
All right. So in this case, there was an affidavit to surrender surety on February 11th. And then he didn't appear on February 24th. And then you're set for jury trial on July 22nd. All right. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Charles Lewis Mullinax.
All right, do you have any prior drug use in your past?
Yes, ma'am.
And what would that be?
Heroin.
All right. And have you ever been diagnosed with any type of mental health issues?
Yes, ma'am.
And have you received medication for that?
I did for a little bit until I got taken off of, like, my insurance got dropped, and then I couldn't afford the medication. I was on it for like a good year though, and I was doing good when I was on my medication.
All right, so I'm going to set your bond at the $4,000. There's going to be regular UAs, a referral to Center for Healthcare Services, and outpatient treatment for substance abuse. Is there anything else?
Your Honor, I was mistaken.
Mhm.
There are two other cases are remanded without bond.
Okay.
000.
All right, state. Look at those.
Judge, we drew on this though, so.
Okay. All right, so then, and the cause number ending in 25, do you all have an agreement?
We do, Your Honor.
And what would be the agreement in that cause number?
I believe that's $5,000 agreement, Your Honor.
Okay. So in that bond, I will do the $5,000. And Mr. Mullinax,
Yes, ma'am.
I'm going to give you the same condition as I did in the previous bond. Don't worry, you don't have to do it twice. It's just so that they can
Yes, ma'am.
mirror each other, all right?
Yes, ma'am. Yes, ma'am.
All right, and then in cause number ending in 86.
Yes, Your Honor, that's 4,000.
All right, Ms. Ferguson, if you'll make sure that he has a reset form for his July 22nd trial date.
Yes, sir.
All right, is there anything else from either side?
No, Your Honor.
Then in that last cause number, Cindy, it's going to be a bond of $4,000 in 2025 CR 002586, a bond of $5,000 in 2025 CR 000525, and a bond of $4,000 in 2025 CR 000524. All right, well, this is what they've agreed to, so I'll go with what they've agreed to. But thank you. And in each cause number, it's going to be regular UAs, a referral to Center for Healthcare Services, and outpatient treatment for substance abuse.
Yes, ma'am.
Is there anything else, sir, that you need to be successful on bond?
Not that I could think of, miss.
All right, if for some reason the referral for the Center for Healthcare Services is not done,
Yes, ma'am.
just contact your attorney and they can contact me and I'll make sure that we figure out what's happening.
Yes, ma'am.
All right, is there anything else?
No, Your Honor, apologies for the messiness.
Oh, no, it's fine. All right, thank you.
Um,
All right, thank you. The court is calling 2025 CR 003821 State versus Lemuel Richardson. Could I have parties approach and announce for the record?
I'll Simpson for the defendant.
And are you Mr. Richardson? Sir, how do you pronounce your first name?
Lemuel, as in like Samuel, but like Lemuel.
Lemuel.
My mother has a hard time saying it too.
All right, hi.
As does his attorney.
I named after my father.
Okay.
Yes, ma'am.
No, I always think that names are very important. Did you understand you're charged with evading arrest detention with prior conviction as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. According to the plea, punishment is to be assessed at 180 days in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes.
Defense?
Is
State.
It is one.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Yes.
I'm sorry?
No contest.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
yes, Your Honor.
Anything you wish to say on behalf of your client?
We'd ask that you follow the plea bargain agreement.
All right, the court will sentence you to 180 days in the state jail facility, give you credit for any time served, and the court will suggest the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, sir.
All right, we can go off the record. How old are you?
I'm
I had one other thing, Judge.
Yes.
I'd ask the court to consider awarding the diligent participation credit.
Oh, if he completes something, then I'll consider it.
Thank you.
I'm 42, I'll be 43. Ma'am. I understand that I've been at this point and just at my age that I've been a criminal. But or at this time, I was dealing with something with my mother. She's an addict. She needs help, and she's here today. I didn't expect none of this when I got out of prison that she was on crack cocaine. And the reason why I was on the east side is for her not to be over it.
But no, here's the thing. When you were caught, you had a meth pipe as well.
What?
So that's what I read in the police report. So here's the thing. If your mother suffers from drug addiction, there's a place that I can pick up the phone right now to get her help if she wants it. But at some point in time, how old is your mom?
She's 16, she won 62.
Right. So she's 62, you're in your 40s. And let me just explain to you all. She's an adult. You're an adult. And there's only one or two things that's going to end up happening to you. This whole situation, when I read the police reports, you could have easily been shot. Because the officer is saying you won't show your hands, you jump off a bicycle, then take off running, then hopping over fences, then going down dark alleyways, then not showing your hands when you're on the ground. And that officer is saying he had to have somebody cover him with lethal coverage. And you know what lethal coverage means? That means there's somebody with a gun trained on you because they don't know if you have a gun or what's going to happen. Everybody at the end of the day, they're just trying to do their job and make it home safely. And if you don't stop using drugs, what's going to end up happening to you is one or two things. Either you're going to spend the rest of your life at the Bexar County Jail or somebody else's jail, or the rest of your life in prison. That's what's going to end up happening to you. Or either your body's going to be in some field somewhere in an alley, right? If you were running in the alley and you got some bad meth and the officer never found you, or the officer said, he was just on the bicycle running, I'm gonna let that slide. Somebody will have to identify your body. And that person is going to be your mother or whoever else it may be. If you are being honest and you say, I'm on drugs, my mom is on drugs, I want to get help for my mom, you can't help anybody until you help yourself. That's why have you ever flown before?
Mhm. No, I'm scared.
Let me just tell you what they say whenever you're on a plane, I listen to what the flight attendant is saying, even though my thing is it's all in God's hand. If this plane falls, we're not over water, we're probably not going to survive, but I still listen. And you know what they say? They say, if you have a child with you, put on your mask, your oxygen mask first. Because you know why? If a parent can't breathe on a plane, they can't help their child. So you're going to have to put on your oxygen mask first before you put it on your mom. And if you get out of the state jail facility and you decide to continue the way you're going, you're going to get arrested, or either you're going to be dead. Those are your two options. You got to make a choice. If your mom wants help, I can send her someplace right now for her to get drug help. But if she don't want it, she don't want it. You understand?
Yes, ma'am.
If she wants it, I'll go get her. I'll make sure she gets the help that she needs today. But you got to take care of you. All right?
Yes.
And when you get released from the state jail facility, if you can't find a place that can help you with your drug addiction, you come back here. I'm still here. I'll pick up the phone. I know a place that will accept you. Okay?
Yes, ma'am.
All right. Good luck to you.
Thank you.
You're welcome. Ms. Richardson, defense counsel, if you want to ask her if she has a drug problem and she wants help, I'll pick up the phone, call somebody, they'll help her. If she's saying she doesn't have a drug problem, then she doesn't have one.
Judge, I can't even see you with my monitor.
I know, and you know,
Only from here sometimes.
and you know what, and the monitor doesn't even work. I don't know, they say they can't take it down and they can't remove it.
Approach.
Sure.
She said she's interested,
Oh, okay.
and but like on Monday, so she can get.
Oh, you need to go now. She should go now. Let me call somebody just for a moment. If she goes over there right now, they'll get a place for her. Just 1 second. All right, so the attorney is telling me that you're saying you need to talk to family and other things. But here's the thing, you're an adult. I can get you treatment today. If you go to where I'm sending you today, they will help you. So it's completely up to you. So this is what's going to happen. Bianca is going to give you the address where it's located. You go over there. What is your name? Your shot, right?
Yes, ma'am.
This may be your last shot. Do not go to a different location, just straight from here to there so you can get the treatment that you need, because anything can happen along the way. Don't get sidetracked. Just stay on the path, and your path is, I'm going to get treatment. I'm going to get treatment. I'm going to get treatment. You understand?
Yes.
Don't get off that path.
Yes.
And the same thing I was telling your son, you can't help your son until you take care of yourself. Okay? And if you ever need anything, if I'm still here, you can always come back to here. I want people to get help. I want people to be successful. I want people to be clean and sober. Okay?
I appreciate that.
And let me just tell you something else too. Anybody that is in your life that is trying to get you off track with your sobriety is not your friend. You shouldn't be talking with them. So once you get on track with sobriety and somebody tries to get you to backslide, like if you're supposed to be doing an NA or AA meeting and they say, you can skip it this time, come out with us, we're just going to a movie. Don't do it, because that's how you start backsliding, okay?
Yes.
So she's gonna give you the address. You leave here, you go there, no stops in between. And they're gonna be waiting for you, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. All right, the court is calling 2019 CR 12495 State versus Tamar McIntyre. Could I have parties announced?
State John.
John Hunter for Mr. McIntyre, Your Honor.
Are you Mr. McIntyre?
Yes, ma'am.
All right, state defense has filed a motion for new trial. Have you had a chance to review that?
I did review.
And are you ready to proceed on it? All right, so the court has read the motion for new trial. I think the motion for new trial clearly has the defense's arguments in it. So with regards to number one,
Yes, Your Honor.
any rebuttal?
Yes, Your Honor. And that, I believe that's the NCIC, TCIC.
Yeah.
Argument, I guess, of the offense. Our position is that we did make it available during court proceedings, and they had access to the actual TCIC, NCICs. And through our understanding of the policy is that we can't allow them to duplicate or keep or make copies of. And that's by, I believe, state orders on that. So that's our position on that front.
All right,
Megan Dowling for the state, just briefly, if I could address that point, and I want to reiterate the arguments that I made at trial, which is that 411.083 of the Texas Government Code is what governs the dissemination of the criminal histories. They were provided to Mr. Hunter, and that's stipulated to in the motion. He states that the state did provide him those. And so that is our position. It would have been a violation of law to allow him to keep them or to reproduce.
all right. And then defense, because it's your motion for new trial, I'll give you the final response with regards to the state's answer to defense's number one.
Yes, Your Honor, and forgive me, I did not prepare to proceed today. I came to court because the law requires me to show you the motion within 10 days.
Yes.
And so I haven't, I wasn't anticipating actually discussing the merits of it today, but if the court wishes us to proceed with that, I mean, our position with respect to the NCIC argument is fairly simple. We cited you case law, which the courts have addressed this subject matter before and have recognized that it is covered by the Michael Morton Act and that it would be required to be produced. As a practical matter.
Well, you're saying produced, but the state is saying that they did produce it. They just didn't allow you to copy it or leave with it.
It was given to us on the first day of the trial. And in the process of trying to make use of it and note it down, we got into an argument about whether or not we'd be able to photocopy it, which we immediately brought to the court's attention. We had an argument in which the court concluded that we were not entitled to copies of it, which we
Well, does the law say, that you are allowed to make copies?
I believe that that is what those cases that we have cited for stands for, that proposition, that it is
But-
producible under the Michael Morton Act in all ways that other discovery is producible. The state's contention that there is a statute that privileges it from disclosure, I think, is being misinterpreted.
Okay, they're not saying, and correct me if I'm wrong, they're not saying that it doesn't prohibit them from disclosure. They're saying, yes, we do disclose it to you, but you're not allowed to copy it or leave the courtroom with it. Am I misinterpreting what's being said?
That is their argument. Yes. Your
All right,
Honor.
so-
We just disagree with that position. I don't think the law supports it. And we also would maintain, as we maintained at the trial, that as a consequence of, well, let me rephrase that. To the extent that there is any countervailing or overarching privilege that would run afoul of the case law that we've cited, Your Honor, about its discoverability, or that would limit our ability to use it from how we would otherwise be entitled to use discovery. I would maintain that that privilege is waived by two separate independent actions. The first is this isn't a situation where we're trying to snoop on these people's lives outside of the context of defending Mr. McIntyre. He is indicted. The state made that decision. When the state or the government have a privileged interest in the privacy of certain sensitive information, and they elect to indict someone for a criminal offense over it, then they can't be in the position of being able to still hold on to that privilege. They waive it. Secondarily, they have run the TCIC and CIC for these individuals, which is the triggering event. The database is curated not by this office. It's curated by the Texas Department of Public Safety and the FBI. They query that database. They are only allowed to query that database if they have a good faith reason to do so in the execution of their duties and responsibilities as members of the district attorney's office. They can't just go pull NCIC, TCIC on you or me because they're upset with us or they for a petty
You're
difference.
saying that they were upset with somebody, that's why they,
No, I'm giving this as an example. I have had cases in the past where I have defended policemen who were accused of improperly querying the TCIC, NCIC database for petty reasons.
so we're
personal
not
reasons.
saying that any NCIC, TCIC was queried without a good faith basis.
No, in fact, quite the opposite. We know that there was a good faith basis because this is the TCIC, NCIC for their witnesses. And Brady versus Maryland and every case that has come since it says that they have to give me that information. That
Okay,
is a
so
requirement.
then the
So-
main argument, and so let's stick with what the argument is. And if I'm wrong in interpreting what's being said by both parties, the argument is not that you received the information. Your sole basis is that you should have been allowed to photograph or reproduce or take the item, the NCIC, TCIC with you.
We
Was
wanted,
that your?
we wanted to be able to use it in every single way that you can use.
No.
the
My
paper.
question, I'm trying to get to specifics. The specific is,
The
well,
specific,
let me start with this. Number one, was the NCIC, TCIC provided to you? Yes or no?
it was handed to me and I had about 10 minutes with it before we had to turn it back over.
Okay, so now with regards to it being handed to you, then it was handed to you. The next question is your sole objection or request for a motion for new trial with regards to point one is that you were not allowed to photograph it or take it with you. Am I correct in that?
The contention is twofold. The first problem is that we were not allowed to photograph it, take it with us, duplicate it in any way. We had to turn it back over. And as we explain in our second argument, that became an acutely problematic issue because we were unable to make use of that information to respond to the state's argument that for authenticity reasons, we were not entitled to offer Joanna Reyes's prior judgment of conviction at sentencing.
All right, so let's start with this point. First point, state, when was the NCIC, TCIC given to defense? And the prior to jury selection, was this the NCIC, TCIC that was given to the defense prior to the jury selection? Do you remember which witnesses those would have been?
It was for all witnesses listed in the discovery.
So would that all also have included Joanna Reyes?
That's correct, Your Honor.
So you're saying that was given prior to jury selection?
It was not.
All right. So it's the court's understanding that for purposes of cross-examination, NCIC, TCIC are considered timely if they're given before cross-examination. But my understanding is that the state gave it to you prior to jury selection. So the first question is, were the NCICs, TCIC given to the defense prior to jury selection?
A stack of paper was handed to me.
No, my question is,
I want to make sure the record is clear.
I want
because
the record to
court's
be
question
clear
is
too.
not accurate. I mean,
I want to know, they're saying that they gave the NCIC, TCIC of all witnesses to you before jury selection. And it seems your main complaint in here is regarding Joanna Reyes. So my question for the defense is whether or not the NCIC, TCIC for all the state's witnesses, were they given to you prior to jury selection? Then we can handle your other point.
the word given is not a word that I can address in that.
Were they handed to you?
I held them in my hand for a few minutes. I didn't have an opportunity to digest their contents fully. I wasn't allowed to copy them. Almost immediately afterwards, I was told that their position was going to be that I wasn't going to be allowed to copy them. I had to instruct my
Okay, so
staff.
here's the thing.
Let me just finish real
No,
quick.
no.
You know what?
No,
I need to-
because
I
no,
need to
stop. We're taking it one point at a time. My first question is, were they given to you prior to jury selection? It seems that your answer to that is yes. Then we'll get into what you were not able to do with them. So the record is clear. My understanding from you is that witnesses who are going to testify in the state's case in chief, their NCIC, TCIC was given to you prior to jury selection. Now that that's been established, then the next question becomes, what were you able to do with the NCIC, TCIC that was given to you?
Nothing.
All right. So you said, were you allowed to elect, because in your motion, you say you were not allowed to electronically duplicate. Were you allowed to electronically duplicate them?
No,
Were you allowed to copy them?
no,
Were you allowed to photograph them?
no.
And I'm taking that straight from your motion. So state, with regards to the NCIC, TCIC that was handed over to the defense, you're saying it was all of your witnesses in the case in chief.
Yes, Your Honor.
The defense is saying they were not allowed to electronically duplicate, copy, or photograph any of the NCICs, TCICs. Now, why were you not allowing the defense to either electronically duplicate, copy, or photograph the NCIC, TCIC?
Because I didn't want to be charged with a misdemeanor offense.
All right, and where are you obtaining that from, the fact that you would be charged?
Your Honor, I previously stated, there are two subsections of law that govern the dissemination of criminal histories. The first being Title 28, Part 20 of the Code of the Federal Regulations, and then the second being 411.083 of the Texas Government Code.
All right, so the state is saying that they could not allow you to electronically duplicate, copy, or photograph based upon Title 28 of the Federal Code and also Chapter 4 of the Government Code. What is your response?
Several things. First, we do not believe that those provisions prohibit a defense lawyer from taking possession of the criminal histories for the purposes of defending a man at trial. That is not the purpose of those laws. That is our position. Secondly.
All right, let me just stop you for a moment. When you say taking possession of it, what do you mean by it doesn't prohibit you from taking possession? What is your definition of taking possession of the NCIC, TCIC, as you see it?
A lawyer should be able to keep the paper with him for the course of the trial so that it can be read, it can be understood, and it can be researched further.
All
And
right.
none of those things were able to be accomplished. I was unable to finish reading the histories. I was unable to digest their contents or understand them or make any meaningful use of them. I was unable to copy them so that I could do that when we weren't in court at recess at any point.
All right, so when you say taking possession, you mean keeping the paper. And when you say keeping the paper, for the record, we're talking about the NCIC, TCIC. When you say keeping the paper, do you mean leaving the courtroom with the paper?
I mean, right, I could not leave the courtroom with the paper. I could not photocopy the paper. I could not make use of the paper. And we had to give it back at the end of the day or at some point during the process. I wasn't able to read or digest the information while I was participating in my other roles as being Mr. McIntyre's lawyer. Counsel said it was handed prior to jury selection. That sounds right. I don't have independent recollection of the day, but we were involved in jury selection for all day and into the evening. It was a lengthy process, and so there was not an opportunity to make any use of it. Also, I can just say, Your Honor, in both federal and state trials that I have participated in, I have never had this issue come up before. I have had prosecutors with the Department of Justice hand me the Jenks material, which would include the criminal history material, prior to the commencement of trial. I understand that the Jenks Act similarly narrows that compulsory moment of disclosure to when the witness is passed for cross-examination, but almost every judge in the United States has recognized that while that law may be that that's when it must be produced, that isn't a fair system. It doesn't provide for meaningful cross-examination. of
Okay, then
witnesses.
somebody needs to change the law. And counsel, I'm sure as you're aware, sometimes people do things that are inappropriate legally, but they do them and nobody ends up saying anything. Nobody ends up charging anybody within anything. But in this court, I'm just here, Mr. McIntyre, to listen to arguments and follow the law. That's my role here as far as this case is concerned, because the jury trial is the parties that made the decision.
But Your Honor, what
So-
I'm saying is I don't think that the law has to be changed because I don't think that the law comes to this conclusion. I think that the conclusion the state's asking you to draw from it is not what the law means in its full synthesis, and that the court's responsibility is to allow the lawyers to be able to provide a meaningful defense to the defendant, which includes having access to the impeachment material that is involved in the case. And in particular, Your Honor, what I think we also need to draw clearly is that this isn't just about the general frustration, although there is that general frustration of not having the ability to use that information and have it on counsel table's desk at the exact time that we are in cross-examination or preparing the evening before with that information. Those things all occurred. And so there is a global harm there. But the specific and acute harm, and the reason why a new trial should be granted in this case, is because, as ground two establishes, we have a situation here where the prosecution has misrepresented the criminal history of its most important witness and did nothing to correct that record, even though the very documents we are talking about here, the TCIC, NCIC records, are the proof that it was a misrepresentation. And so that's what really ties this thing together, is that the TCIC, NCIC is being used as both a shield and a sword against the defense. And that's not its purpose. That's the bigger overarching issue here. And certainly with respect to both constitutional law, as it pertains to what due process of law for a criminal defendant means, and in terms of the full synthesis of why these laws exist and what their purpose is and how those things are supposed to operate, it simply is not the case that the court could not authorize the defense to have access to that information during the proceedings. And we were amenable then, we told the court we were amenable then, that we would have taken it under protective order. But that option was not explored.
All right, so with regards to the defense request for motion for new trial under point one, that will be denied. Point two, misstatements of the prosecution in closing argument. What misstatements?
The the state in closing argument told the jury that Joanna Reyes should be credited with belief because she had abided by the conditions of her bail on her tampering case, on her capital murder case, and had not done anything illegal, had not broken the law. And we quote the argument verbatim in the motion. We approached and explained that's just simply not true. Joanna Reyes, after she was charged in Mr. McIntyre's case, and after she entered her plea of guilty to tampering with evidence, and after her sentencing was held at abeyance and postponed pending the outcome of Mr. McIntyre's trial, she went out and obtained criminal conviction for the felony offense of credit card and debit card abuse. She was also arrested and charged with unlawful carry of a weapon. That case was dismissed because she pled to a different offense. We've included all of those records that we've obtained from the Harris County clerk as exhibits in the motion for new trial, which we'd ask that the court receive. We also made a bill of exception at the trial of the judgment of conviction for credit card and debit card abuse at the sentencing phase of the trial, which we'd ask the court to take into consideration as well. There's just no question that the state told the jury something that isn't true. Now, listen, I think Jason Garahan is a very reputable, honest, and hardworking prosecutor, and I have immense respect for him. I don't know why they said this, but it's just not true. It's objectively
All right,
false.
response.
Well, Your Honor, with respect to the statement, I trust that their motion states what I said during argument, which is closing argument during the guilt innocence. And what it may be, slip of the tongue, or the fact that I misstated that Joanna Reyes had I don't know exactly what was said, but alluded to the fact that she did break her bond is something that can be argued, that was done by mistake on my part. That may be, but the fact remains is that defense counsel knew about this and did not bring this up during her cross-examination. And the fact is that the jury is well aware of her credibility or credibility issues, if you may, of her being a co-defendant to a capital murder and of her testimony that she gave during the portion of guilt innocence. And touching on the subject of the prior judgment, defense had every opportunity to recall Joanna Reyes onto the stand during punishments, which they chose not to do. And, if they considered our duty or their duty, the fact is that their client was the one that was facing 5 to 99 years of life. And they could have called back Joanna Reyes and questioned her on the subject, and they chose not to. That fact does remain there, Judge. So that's the state's position on it.
Judge, and just one more thing, closing arguments are just that, arguments, they're not evidence. And the jury was instructed about that multiple times. And so that would just be another argument regarding that.
All right, with regards to point two, the motion for new trial will be denied with regards to point two. All right, thank you.
May I be excused, Your Honor?
Yes.
Just to let you know about that, I talked to Adam.
Mhm.
And, I sent an email off to our investigator to check into another SCPD case number that's possibly associated with this, his client's case. And I know that he probably won't mind me telling you that he doesn't want to go forward until possibly there's an answer on that.
All right, Norma, on Mr. Alaman then? Let me go into the calendar. Mr. Alaman? I know I'm mispronouncing your name. I am so sorry. You can come down, please.
If you want to put my head out there and see if it's there.
Sure. I'm going to give you a new court date. Your attorney believes that there may be another case that's pending, and he'll need discovery on that. So what I'll do is I'll bring you back on June 26th. And if your attorney wants you brought back sooner, he'll let us know. If there are any other motions to be filed, he'll let us know, okay? All right, thank you. Deputy Laura,
Yes,
then he can go back. And who is the person, Colorado Springs? Oh, okay. So we're gonna bring him, Mom, we're gonna bring him back on June 26th. If his attorney wants him back sooner, we'll bring him back sooner, okay? Thank you.
Just looking over.
Nice.
Just looking over. Go around the corner.
All righty, so our intern who was in here, the one who gave me the Christmas plant that is still surviving and thriving, she just finished her first year at St. Mary's. Yes, and she said, I've been selected to be on the international moot court team in mock trial, and she's gonna be on the clinic. So I'm like, yay, so pretty soon she'll be joining us. But oh my gosh, time flies by quickly. Good morning.
Morning.
Good morning. All right, the court is calling 2025 CR 0022426 State versus Axel Ramirez. Can I have parties announced?
Megan Galloway for the state.
Trey Maurer standing in for Robert Maurer for Mr. Ramirez.
All right, and are you Mr. Ramirez?
Yes, ma'am.
Mr. Ramirez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you understand you're charged with intoxication, assault with a vehicle, serious bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. And counsel, it's the court's understanding that he's only applying for community supervision. Is that correct?
That's correct, Judge.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication. The state opposes your application for community supervision. They will take in consideration 2025 CR 0022422, and there's to be restitution of $100 to the complainant. Did you understand that to be the plea?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right, after reviewing state's exhibits one and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. If you would like, I can set this for a PSI. It's going to be probably 8 weeks because that's the time frame. Or if you all would like, I can set it sooner and you can have whatever witnesses you would like to bring in to testify.
Your Honor, can we take a step back and confirm real quick,
Sure.
figure out what lead counsel wants to do on that?
Sure.
You said either 8 weeks or,
Or we can come back sooner, but that would mean you would be waiving your PSI and I would make a decision based upon whatever evidence is presented to me.
okay, let me take a step back and confirm real quick. Thank you,
All right,
Judge.
thank you. All right, yes, Mr. Mauer.
You're gonna request a PSI, Your Honor.
All right, I need a PSI date on Ramirez.
July 14th.
All right, it will be July 14th. July 14th, yes, you'll sign the reset form. So that's going to be a PSI and a TAP evaluation. And before you leave, speak with probation and they'll let you know what you need to do.
Okay, ma'am. Thank you.
Okay, you're welcome. Court is calling 2024 CR 2791A State versus Ethan Anthony Rosales. Can I have parties announced?
Megan Gallery for the state.
Trey Mauer, standing in for Robert Mauer for Mr. Rosales.
And are you Mr. Rosales?
ma'am.
Did you understand you're charged with deadly conduct, discharging a firearm at individuals as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 7 years in the prison. There's a $1,500 fine and the state is silent on your application. Did you understand that to be the plea?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right, after reviewing state's exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. All right, on this case, same thing. You want a PSI?
Yes, Your Honor, we do want a PSI and we're gonna request that it be on a Friday. My client's father, who's here today, he works during the week. The only day that he can be here is on Friday, and he's going to be a witness for us at the sentencing.
He can zoom in as a witness.
Your Honor, I believe he say he works in the oil field, is that correct? So I don't think that he's able to Zoom while he's out there.
All right, well, we can try it and see if Zoom work. If it doesn't work, then we'll figure something else out.
Okay,
Normally, Fridays are scheduled for weird trial.
okay. I just want to make sure, Your Honor, that if we show up and he's not able to Zoom in, that he will be given an opportunity to reschedule so we can try to get him here for the
Yes.
sentencing. Okay.
All right, so do you want to set this on the same date as the other?
That works for now, Your Honor.
All right, Ms. Ferguson, if you'll put this then on July 14th. All right. Once you sign the reset form and speak to the probation, you can leave.
Yes, ma'am.
All right, have a good day. Thank you.
Your
for
Honor.
addressing appropriately.
Have a good weekend.
You too. All right, so you filed a motion for a bond. The reason why he doesn't have a bond is because he failed to appear
Yes, Your-
February 18th.
yes, Your Honor. And
All right, we'll go on the record. Court is calling 2024 CR 012895 State versus Mario Alberto Tovar. Can I have parties announced?
Megan Gallery for the state.
Christopher Simpkins for the defense.
And are you Mr. Tovar?
Yes, ma'am.
All right, defense has filed a motion requesting a bond. State, have you had a chance to review that?
Yes, Judge.
All right, counsel, in your motion, you say he is entitled to a bond and actually he is not if he has previously failed to appear. But
Yes.
what I'll let you know, I'm keeping an open mind.
Yes, Judge. And I believe the reason that he failed to appear is because he was in an inpatient facility, which I did not get the case till January of this year. And I believe he went into the inpatient facility in December. December 12th.
All right, do you have documentation of that?
He was benched back to Bear County. I'm working on getting the documentation, but he was benched back to Bear County, which the system should reflect that.
Okay, let me see what the system reflects. All right, so we're off the record. So what I see in the system, there's an affidavit of surety file, affidavit to surrender surety, August 2024. Then we had an affidavit to reinstate bond on September.
And
He was-
Then there was a warrant return. I don't have that he,
He was booked in on May 6th, I believe, and he was transferred from which class?
Gloucester.
let me see. Let me go to the next screen.
On September, I was, they didn't, I paid the bond and they.
No, talking about when you were brought back, or when you were brought to Bear County, which county were you brought to?
From San Diego, Texas. Glassberg Union.
I don't have that listed on here. To the clerks, can you all see if he was brought back from a inpatient facility or something? Because I don't see
He was
that.
discharged from the inpatient facility once the warrant, so that they could bench him back.
But Deputy Lord, thank you for giving me that information from the jail.
You're welcome.
Defense counsel said that he was in an inpatient facility and was bench warranted from the inpatient facility.
San Diego, Texas, I believe.
You know, I was in Eagle Pass, they sent me from Eagle Pass to the Glassberg unit, and then from the Glassberg unit, they sent me in.
But you're saying that you were in an inpatient facility?
Yeah, it was a safety.
Oh, okay. So he's saying he was sent to safety,
That's for, he has a
and
paper.
then that from safety, he was brought
Yeah,
here.
and he was discharged from safety because of the warrant out of. Bear County.
Okay. Well, that should be easy to find out.
A lot of the counties in down there have very good.
And so what were you on probation for in the other county that you were sent to safety?
It was a drug charge.
All right, so they don't have anything that he was bench warranted back from safety. I didn't have anything in my system either. But here's the thing, I may not have anything in my system, but it will be easy to get that information at a later date. So we're back on the record. What are you requesting?
I would just ask that the bond be reinstated in the original amount. I know that the bond itself cannot be reinstated, just the original amount. I will see if the bond company is amenable to reinstating their bond in it, just so he has the option to make one.
And state, what are you requesting for bond?
Judge, the original bond was $10,000, so we're requesting a bond to come out $1,000. This condition.
All right. So this is what the court is going to do. Based upon your telling me that you're in safety, if your client can bring back proof to the court that you are actually in safety, then I will reinstate the bond amount to the $10,000. But for now, your bond is going to be set at $20,000 because the only thing that I have is that you didn't show up for court. And bond is supposed to be high enough to make certain that a person will appear, and you didn't appear when your bond was at 10,000. But if it turns out he was in safety, your attorney can come back and I'll set the bond at $10,000. But for now, your bond will be $20,000. There's to be regular UAs and outpatient treatment. All right, is there anything else?
Nothing further, Your Honor, thank you.
All right, so Ms. Ferguson, can you make sure that he has his reset form?
Yes, ma'am.
And I believe he's set
July.
July 8th. Yes.
Sure.